Throughout this document, we talk about intake. As I alluded to in the text of the document, I had the best mentors of intake in Dr. Becker and Dr. Slayton. And they, throughout, dating back to the mid-'80s, Dr. Becker and I talked about how do you get consumers to go directly to mediation, ADR, before you go to file a lawsuit. And use small claims to make this point. You could have a conflict of any type, but use an example maybe of a conflict with you and a lawyer. You and a neighbor, excuse me. And you might try to reach across the fence and verbally resolve it. If the party doesn't acknowledge the dispute, or if he or she thinks sort of they're the right, or they're going to retain an attorney, they might gamble that I don't have the financial means or energy desire to file a lawsuit. All this factors into the psychology of a dispute. As a psychologist, person with 2 master's degrees in psychology, we know 90 to 95% of conflict is based on the psychology and perceptions of the parties. So it's always the power. So in small claims court, which is where you might go for certain conflicts and that you don't even want to have attorneys for in the first place, or but you have to file a lawsuit. They made it really simple form. There's usually dollar thresholds and amounts, but the power of capturing is where you are capturing the possibility of capturing the dispute directly is limited, because most people don't respond until they get served papers, and you get 20 to 30 days depending on the state to respond. If you don't, you get a summary judgment. And so that is why ADR, it was positioned as an alternative. Why didn't consumers 50 years ago bypass the legal system and go straight to mediation? Now, we don't advocate, TeDR is not about mediation. TeDR is about facilitated, human-factored, heavy AI electronic negotiation. Our patent pending technology negotiates for the parties. It is often argued that lawyers or law students who attend law school don't really get any in-depth training in negotiation principles and practices, maybe 1 semester course. So it's advantageous to the legal system and attorneys who've go to law school and invested in their prospective firms and promotion of their prospective businesses. It's not advantageous to have consumers go en masse directly to mediation or any type of alternative dispute resolution. We see that changing. Doctors didn't foresee telemedicine. Doctors didn't foresee minute clinics that gives a consumer that's got an ailment a chance to go straight to see a doctor or a physician assistant, get the prescription filled right there at the pharmacy, and so it's changed medicine. But for the most part, the legal industry hasn't changed. So we see that changing, and we see that why don't we try it before you file a lawsuit? Take the conflict, understand, as we talked about Resolve Talk, being an impetus to changing where you can get legal advice, your standing, the issues. But mediation has never been considered legal, or alternative dispute resolution has never been considered legal. And so we think it's the power of the consumer and the applet that's going to switch the pendulum and allow people to get a mindset that they could try this for 30, 45 days before they hired a lawyer. And if we could take 10, 15, 20% of the conflicts off of the court docket and give the consumer a better and easier, simple way right from their phone to resolve it, then and only then will that shift and pendulum happen. Thank you.